Construction projects, redevelopment, real estate projects are generally experiencing the litigation. There are ways of resolving the disputes. Generally, people go to the courts for resolving their disputes and exploring their possibilities of getting the reliefs. One more interesting alternate dispute resolution mechanism, which is generally followed as a fast track dispute resolution mechanism, is mediation. I'll explain the difference between mediation and the litigation. Building disputes can be stressful and very costly. It is also time consuming. In this video, I try to explore the benefits of mediation as a more efficient and collaborative alternative to litigation, which is traditional in nature, and providing insights into how it can help resolve disagreements and save both the time and your money. You need to understand when you approach the court, you need to have some solution in mind because either parties know that they are somewhere right and somewhere wrong. The whole thing is all about resolving the dispute with respect to the construction projects. It can be really stressful. The building disputes can make them even worse. In this video, we will explain how to resolve these issues with mediation and litigation. The stress of building disputes. Here, we need to understand when a building is under construction, how number of issues can come forward, and for every type of dispute, there can be a legal solution through the court of law. And if the parties are willing to come across and sit across the table, appoint a mediator, can narrow down upon the issues and try to work out an amicable solution. What is the common dispute between the party and the builders, landlords, stakeholders, government, and other parties involved in the whole project? We need to understand in a very highlighted manner the common causes of building disputes, whether the disputes are relating to your contractual obligations, breaches, and faulty constructions or delays. These are the general grounds, common causes of construction disputes. Apart from that, the emotional toll and financial strain which the building disputes can cause is very high. The problem can be understood in a very detailed manner so that we need to work out what are the possibilities of resolving a dispute with respect to the legal rights of the parties and contractual obligations. Traditional method of resolving a dispute is always litigation, approaching the court and putting yourself into the procedural aspects of proving your claim with respect to money and also with respect to your entitlements in terms of legal rights. It is termed as a costly and very time-consuming approach. The complexity and length of legal procedures involving lawyers, courts, and potentially years of litigation. When a party is no more, a landlord has expired his legal heirs, searching those persons, bringing them on record, and resolving the issue itself is going to take number of years. At times, we spend months to just reach a party to serve a copy of the pleadings or notice, and thereafter, after the trial, evidences, cross-examination, arguments, and then final argument, and then order, judgment, decree, and then execute them in case no appeal. If there is an appeal, file an appeal, contest the appeal, then hierarchy of courts, the district court, high court, supreme court. Alternatively, many agreements have alternate dispute resolution mechanism as arbitration. Again, some procedure is involved. If you are losing, you need to come before the high court, again challenge the award, deposit some money, and then take up the matter in the high court. for few years and then further Supreme Court and again litigate for number of years. Traditional approach is now known to everyone that the party who's in before the court has spent a lot of time and money with respect to the uh, lawyers' fees, court fees, conveyance expenses, and also escalated costs. Even builders are generally willing to come forward for mediation or arbitration and resolve their disputes. The power of mediation. What is most important aspect of mediation is it is a collaborative solution. No one party is dictating the terms. Explaining the whole process by the mediator with regard to emphasizing how this is a whole voluntary process and how it is confidential in nature. Even sub judice matters which are pending before the courts, can be resolved through the mediation process. How mediation empowers the parties to control the process, irrespective of the litigation and the procedures and the laws involved, parties can formally discuss the matters in dispute, decide the claims, and decide their outcome. And this will be facilitated by a learned mediator who will be generally on the panel of the High Court or having sufficient qualification and experience in the field of law, civil engineering, and other related fields. The benefit of mediation is it is very, very cost effective and effective in terms of time. You can save a lot of time and you can preserve your good relationship among the parties. There will not be any heartburns because mutually parties are agreed to the terms of agreement, that is consent terms, which gets filed in the court in case of pending litigation. Now, what is the last point? Like you need to appoint a very, very learned and qualified and a right mediator who will come with lot of real world examples, how many projects he has handled, because generally clients ask whether you have handled this kind of case, this kind of project, this kind of mediation activity. A learned, experienced mediator can resolve your disputes in no time because the reputation which a mediator and the process of mediation brings has ensured that if you believe in this system, the results can definitely follow. Importance of choosing a right qualified and a person who is on the panel as a mediator is definitely very high because if you go to a reputed mediator, everything will be very, very crystal clear and parties will get suitable opportunities, and with his experience you will be able to resolve your disputes at the earliest. Factors to consider while settlement: both the parties have to put up their claims before the mediator and agree on final terms so that with multiple meetings the solution can be worked out, because ultimately every society, every builder, every litigant's aspect with respect to construction is to get the building constructed at the earliest. So mediation is definitely a very high possibility it brings for resolving the disputes. The amount of skill the experienced mediator is having is definitely going to play a very good role in terms of resolving the dispute. Now, once you agree on a term to close your dispute, you can work out a consent term with terms and conditions and timelines, and based on which the same can be signed by the parties, their advocates, and also the mediator, and the same can be filed before the honorable court for drawing the proper decree in terms of your agreed settlement. Therefore, if you ask me whether it is good to go for mediation or litigation, I will definitely advise and strongly recommend go for mediation and resolve the disputes at the earliest possible and concentrate on your business and develop your building at the earliest. Thank you.